It's nice. It's nice to see you.
I'm just waiting for us to start broadcasting. Oh, we're live. Okay, perfect. So, hello everyone.
It's nice to see you.
Hello everyone. Welcome to our Legal Info 101. For us to start broadcasting. Legal Info 101 session. Sorry about that. And I will introduce our guest today. So basically, first, we're going to hear from Arish Riahi, a Montreal lawyer with deep roots in grassroots and social justice work, whose practice primarily works with local activists, students, and people from marginalized communities in Quebec, and focuses on cases dealing with issues of racial profiling, mental health, constitutional rights, and civil liberties. And then following that, we're also going to hear from our legal information clinic on legal considerations related to immigration or international student status as they relate to activism and social justice work. So without further ado, I will introduce Arish Riahi.
It's my turn.
Mm-hmm.
All right. Hello. I cannot see who is in attendance, and this is the first time that I'm giving the workshop in this context, this virtual context. Definitely, I feel more self-conscious than when we do it physically. So I hope that I get to answer all of your questions. I don't know if we have clarified how the questions would work, I guess at the end, Nicole?
We can do it at the end, or we can do it as we go. It's up to you.
Okay, I like as we go. That way we can be sure that people understand. I like to start this workshop with a few disclaimers. I did not consent to this being recorded, and I want to explain that I am mindful of accessibility issues. However, I am working on my end on having this workshop being available on the internet on a free basis. So we are working at the office on already a video that would be a lot more, I guess, easier to navigate. So that's why this workshop is not recorded, but eventually it should be available online. So that's the first thing that I wanted to clear up. Everything that I will say is constitute general guidelines, things to watch for, variables to be mindful of when you negotiate what is your level of consent before entering political action, whether it's direct action or it's going to a demo. So this is all legal information. It's not legal advice. If you wish to have legal advice, probably you need one-on-one time with a lawyer who can help you according to your personal situation. And that brings me to something else. I like questions as they go. Like I said, I really like when I get to see if people understand, and it gives me an opportunity to formulate things differently. That being said, I will not, and I'll tell you, but I will generally not answer questions if they feel too personal. So if the question is sort of disguised as a theoretical one, but it's clear to me that you're talking about your personal situation or somebody else's personal situation, then I will tell you that this is not the place to do it, and we can do it in another setting. Yeah, the workshop, I've been giving this workshop for I guess since 2017 or something like that. The workshop is geared in a way that you don't have to memorize anything. Feel free to take notes if you have to, but the general idea is that you leave this workshop with enough information and conveyed in an accessible manner so that you can share it with your loved ones. And I think we can summarize the whole workshop in 5 or 6 sentences. So let's make sure that everybody understands those 5 or 6 sentences, guidelines as well. Je parle très bien français, alors si vous avez des questions en français, je peux vous répondre en français et je peux traduire aussi pour les autres personnes. So let's do this Montreal style Franglish if some people require it. All right, so let's jump right in. Oh yeah, I forgot one last disclaimer. The legal information that I'm giving you today is relevant if you are basically walking outside. So if you're leaving a demo or you're walking down the street or whatever it is, the premise is that you are in a public space or semi-public space, and yeah, what does that mean? It doesn't work if you are inside a car or you are at home. Those are two different workshops, and they require 3 hours each to make sure that things are different. So any questions regarding what's going on if you are at your house or what's going on if you are in your car, those are outside the scope of this workshop. In this workshop, we focus on you peacefully minding your own business, and then a police officer comes see you. So let's start there. You are peacefully minding your own business, and then there's a police officer that comes up to you. What do? The general recommendation on my end is that you listen to what the police officer is telling you. Police officer comes up to you and he says, "Hi, how you doing?" You have a choice at that point to answer or not. I recommend answering with a question. If you don't want to talk to the police at all, I recommend asking a question right away. If you want to talk to the police, if you want to have small talk to the police, that's up to you. There's no legal advice that covers that. That's your level of comfort. But if you don't want to talk to the police officer and you are questioning whether you have to talk to him at that moment, the best way to deal with it is to ask him a question right away. And the question is, am I being detained, officer? It's a pretty closed question in the sense that it can be answered with a yes or a no. If you get a gray area, if you get a, I guess, open answer that you don't understand, do feel free to repeat the question. Am I being detained right now, officer? If the answer is yes, you are being detained, then definitely you have to stay there. If the answer is no, you're not being detained, we're just chit-chatting, then you are free to go. At that point, it's that simple. If you are not being detained and you are free to go, you do not need to ask for further permission. If you're not detained, you can just pick up your things and leave without saying bye. That's the beginning and the end of it. So, police officer comes up to you. Hey, how you doing? You can entertain him if you want. If you don't want to, then you ask, sir, all the cops in my workshop are male, by the way, so I'm going to use he. So, sir, am I being detained? Yes or no? If yes, you have to stay there. If it's no, then you leave. That's the first guideline. The second guideline, if you are actually being detained and you have to stay there, then be mindful that at that moment, you do have constitutional rights that kick in. Generally speaking, in criminal law, there's this very delicate balance between what you have to do and the protections that are owed to you. So it's always a trade-off between your obligations, your legal obligation to conduct yourself in a specific manner in front of the police officers. So you do have rules that you have to follow. And at the same time, you do have very important protections, and these are constitutional protections. What does that mean? It means that these protections are inside the Constitution. The Canadian Constitution includes the Charter of Rights, and it's the Charter of Rights that contains your constitutional rights. So if the police officer is telling you definitely you are being detained, you know that means that you have to stay there, and you know that means that you have to talk to them. Now, talking to the police officer is not a free wild card. There are rules that tells us what is it that you have to tell them and what is it that you don't have to tell them. If you're being detained, generally the next question or the next thing that the police officer will ask you will be to identify yourself. And this is an obligation. Coming back on the fine line that I was talking to you about, between your obligations and your constitutional rights, identifying yourself if you are detained is an obligation. So you do have to answer that question. If you don't answer the question of your identification, then you expose yourself to a criminal charge, and that criminal charge is obstruction. What does identification mean? So The police officer will ask you to identify yourself, and he will ask you 3 different questions. What's your name? What's your date of birth? And what's your address? So let's recap. Police officer comes up to you. Hey, how you doing? Sir, am I being detained right now? Yes, I need you to stay here and identify yourself. How do you identify yourself? Name, date of birth, and address. That's it. That is all that you have to say. So again, repeating, you must identify yourself if the police officer is asking you to identify yourself. If you refuse to identify yourself, or if you lie in your identification, if on purpose you give wrong information, that constitutes a criminal charge, and that criminal charge is obstruction. It's called obstruction. So if I just taking some notes so I can make sure that I don't forget anything. All right, so identification. Let's talk about name, date of birth, and address. It seems quite simple, but it's not simple for everybody. Generally speaking, it's simple for people that have a certain amount of privilege, and it's not simple for the rest of people. So name, date of birth, address. Let's start with address. The address that you have to give is the address that you use in regards to the state. So it is the address that is usually associated with your driver's license, if you have one. It's the address that is associated with your tax return. It is the address at which you will get all the official documents from the provincial or the federal government. Your official address is the address that the state will use if they want to communicate with you. That may be different than the address where you're going to go sleep tonight. That may be different than the address where you hang out. You've been hanging out for the past 6 months. Just keep in mind that for your address to be correct, it needs to be the address that the state uses to speak with you, to send you letters, to send you benefit checks if you have benefit checks, if you have loans, if you have the students, what's the name, the bourse étudiante. I'm blanking on the exact word, but if you're receiving money to go to pay for your studies, the address that is used by that university, by the state, will be the address that you have to give to the police officer. Date of birth is not necessarily there's no controversy usually for date of birth, so you just give your date of birth. In regards to the name, it's the name that the state is using to identify you. So again, it's the name that is present on your official documents, on your driver's license, again, on your carte d'assurance maladie, if you're covered by that. It's the address that appears on your tax return. Again, it's the address that appears, it's the name that appears in your tax return. It's the name that appears on the benefit checks. It's your legal name. To put it simply, it's the legal name. For trans people, it might be your dead name, but you have to use your legal name for the purpose of that identification. Why is it that you have to use the information that the state has on you? Well, it's pretty intuitive. The police officer is going to take the information that you give once you identify yourself, return to the car, type it up in their system, and see if it matches. Simply. They might ask you some follow-up questions. They might ask you, have you ever lived at this other address? Those are follow-up questions if the information that they get once they sort of search your name in their system, it's possible that the address is not the most updated information that they have. So they can ask you follow-up questions, such as, what was your previous address? Is there any other way to spell your name? Is there a middle name that you used you forgot to tell us about? But beyond that, you don't have to say anything else. Okay, so legal name, residence, legal residence in regards to the state, and date of birth. And that's the end of your identification. You fulfilled that legal obligation. You're not liable for a criminal charge of obstruction. And after that, the guideline is to shut up. After that, the guideline is to invoke your constitutional right to remain silent. Beyond identifying yourself to the police officer, there is nothing that you have to tell them. There is absolutely no legal obligation to keep continuing that conversation or answer any other question that go beyond the scope of identification. That is vastly, vastly important. Perhaps now, Nicole, if you wanna tell me if there are any questions right now, I can take a few. Hi.
Hello. So was that...
I can take a few questions because I'll probably be moving to another topic if there are any at all.
Oh, perfect. So are there any questions from the audience before we move on? We'll give just a few moments.
Arish, for the question of ID, right? You know, what if the officer demands to see your driver's license or actual, you know, ID proof? Is that also included?
Okay, very interesting.
Or your passport, or you know, basically any of your official documents.
All right, thank you for that question because it allows me to clarify something that is quite important. So in Canada, and rewind for a few seconds, criminal law is federal jurisdiction. So it applies to the country of Canada. The rules, theoretically, the rules are the same throughout Canada. In Canada, you don't have any legal obligation to carry on you a piece of ID. So nothing forces you to carry a passport or a driver's license on you. This obviously applies to citizens. Anything else, you probably need tailored legal advice. You don't have any obligation to carry ID with you in Canada. Because of that, when you identify yourself, you do have the option of just handing to the police officer an ID card. You can do that, just hand out your passport or hand out your driver's license or anything else, but you don't have the obligation to do it. So your identification can be verbal. The words coming out of your mouth, and you saying, this is my name, this is my legal name, this is my date of birth, and this is my legal address, that is enough for you to fulfill that obligation of identifying yourself. You can use, as I guess, bonus for the cops, you can use identification, you can use paper, but see it as bonus. Your verbal declaration is enough for you not to be facing obstruction charges.
All right, so we have a couple of questions from the audience, actually.
Let's go.
So our first question is from Renee. How to respond when or if the police are using intimidation or scare tactics?
That is too vague for me to give you legal information about that specifically. And the main reason is that there are multiple tactics, and depending on the situation, it might look like different things. Sometimes an intimidation tactic from another perspective is called an investigation technique. So we would spend a lot of time defining our terms, so I cannot give you an interesting and substantial answer to that.
Perfect. And then the second question is from Jacinthe. Regarding declaring an address, do you know what are the requirements for a homeless person?
Yeah, that's a very interesting question. I do not have the exact information as far as how it operates in the streets, so to speak. Obviously, the law would be applied the same way. I do have knowledge of different community groups or different grassroots supporting networks that allow the use of a specific address. So I think there's Sac à Dos, for example, that allow people in a homelessness situation to use the address of that organization so they can get the mail and, get the benefits from the state if they have to, so they can report that as an address. Beyond that, it would, I think a person that works in grassroots support of people in a homeless situation would have a better answer as to the options. But for now, I can tell you that those options exist. But I guess the legal obligation for them to identify themselves remains the same.
Great. So if there are no more questions from the audience, I think we can move on.
Okay, cool. I really like the questions because it really allows me to clarify. So please just keep them coming. Thank you, Jacinthe, Renee, and Walter. Yeah, go ahead.
Just one quick question, okay? No, because what if the police officer says to you, okay, can I have your driver's license? Which is usually, the police officers will be very direct, right? You have your driver's license, but you don't want to give it to them. So, in response, like I made the situation which I said, no, I don't have my license with me, Yeah.
So, I guess definitely.
So then would I be lying, and I would be like, would I be open to obstruction to justice?
Obstruction happens when you don't identify yourself. Not handing out the proper ID is not obstruction. So generally, I find that police officer asks you for your driver's license if you are driving. That is usually the first question. If you are driving and they pull you over, maybe after the hi, the first question is, after bonjour, hi, the first question is, des papiers d'assurance, so insurance paper and your driver's license. We don't see it often that the police officer asks for driver's license if you're walking in the street leaving a demo. Either case, if they ask you that and you have it and you don't want to hand it, perhaps you can ask the question of, is this for identification? Because I can just tell you. If they still want to see piece of ID, then you having ID on you and not giving it out, if you have verbally identified yourself, I do not think that would be an obstruction. Or at the very least, I think we will have fun. We would have a lot of fun at trial. All right, so we recap. Police officer comes up to you. Hey, how you doing? Hold on. Perhaps Walter and Nicole, are you okay staying where you are? Okay, no problem.
We are?
Yeah, because the screen was different earlier.
Oh yeah. We can stay where we are. That's fine.
Okay, cool. So, police officer comes up to you and he asks you, "Hey, how you doing? Am I being detained, sir? Yes or no?" No, you leave without. You don't need to say bye. You can just leave. Yes, you are being detained. Then you will have to identify yourself, name, date of birth, and address. Identification is an obligation. Earlier on, I told you that criminal law is always a delicate balance. It's always a trade-off between your obligation and your constitutional protection. So now we covered your obligation to identify yourself. What are your constitutional rights in that sense? Well, it's the time to call a lawyer. You have at that moment a constitutional right to speak to a lawyer. The charter speaks about this, and it's intuitive. We've all seen it in the movies, people lawyering up and calling their lawyers. One thing that I want to stress is that your constitutional right to speak to a lawyer includes the right to choose that lawyer. So if you don't have a lawyer and you want to speak to one, the police officer will make it that you can call the legal aid office. There's always someone on call who can answer the calls from the station, people that are being detained. There will always be someone to pick up the phone from the legal aid office. So that is a service that exists throughout the province wherever station you are being detained, or whichever state police station you are being detained. Now, if you exercise your right to speak to a lawyer, you have the right to say, I want to speak to this specific lawyer. The police officer cannot tell you, well, no, we need you to call this other person because we don't have time for this. That is a violation of your constitutional right. And time again, we see from the court that they repeat this message. The constitutional right to speak to a lawyer when you're being detained includes the right to speak to your lawyer of your choosing. So do not feel intimidated if the police are trying to have you call someone else or just quickly call legal aid because it's more convenient for them. Make sure that when you assert your right to speak to a lawyer, that you are aware that you can choose who is your lawyer. It does help to establish contact with the lawyer before. If I get calls in the middle of the night, it does help if the message from the station tells me who is my client, and it does help for me to answer in the middle of the night if I know who is at the station. So do establish contact with a lawyer before. Do make sure that you trust that lawyer. There's a bunch of different really progressive and really radical lawyers in Montreal. So there's plenty of choice for you. So we know your obligation to identify yourself comes with the constitutional right to speak to a lawyer once you're being detained. The other constitutional right that kicks in once you're being detained, I spoke about it earlier, is the constitutional right to remain silent. Now, this is where it gets really fun with, I guess, clients that are a bit younger. So we're talking about students around your, around your life situation. I guess the most direct way for me to say it is don't be a smartass. Your constitutional right to remain silent in front of the police officer is extremely, extremely, extremely important. If you wish to speak to the police officer, then you have to know what is it that you want to say. I haven't seen a lot of cases at the office for the past years that I've been practicing. I haven't seen a lot of cases in the office where it paid off to have a conversation with the police officer. You are talking to professionals. And perhaps in some circles, we don't like to hear that, but you are talking to a professional who has received considerable training as far as how to handle people, how to speak to people, how to cross-examine people, how to ask questions. You can be asked, what is it that you had for food last morning? And before you know it, you spoke a whole lot more about the circumstances leading up to your arrest than you thought you did. So things can go very, very, very fast. And at that moment, it's not the moment to try to be a smartass with the police officers. If that is something that you want to do because it gives you some sense of agency, or this is not your first rodeo, you've been through this a few times and you feel comfortable to do so, then that is your level of consent. And definitely, you are the one who chooses. I want to make sure that I clarify to you that the constitutional right to remain silent is probably the only one that is entirely in your control, and is the one that criminal defense lawyers just repeat endlessly and endlessly. I am also aware that it's very hard to shut up once you're facing that situation. It's very hard to not say anything. People in different intimidation, in different intimidating tactics might react differently. If you think that you are heading towards a political action where there might be a lot of arrests, and you think that there's a high possibility of you being detained and asked questioned by the police officer, do mentally prepare yourself for that. Some people like to prepare themselves by already preparing answers to their questions. One answer to the question can be, I just spoke to my lawyer and she told me to shut up, or she'll get very angry. Another set of answers would be, I am invoking my constitutional right to remain silent. Another answer can be, I'm not talking to you, man. It doesn't matter how you phrase it. It just matters that you really enforce your right to remain silent. And the police officers, generally speaking, at the station, they're very respectful of this because it's very easy, or at least it's easier down the line at trial to prove that constitutional right was breached by the police officers, in the sense that as soon as you enter the station, then they have to record everything. So it's something that we can even see from the paperwork if that right was breached. So do prepare yourself, do prepare some sort of answer, so it gives you a sense of agency to establish some limits, establish your boundaries, if we can say it clearly, but also know that it's not going to be a fight between you and the police officers. Generally speaking, after a few times of you saying, I'm not talking to you, and especially if this is happening after you spoke to a lawyer, they will leave you alone. Now, some of you that are paying very, very, very close attention, or have seen this workshop before, or have already been arrested, you probably noticed that I did a bit of a logical leap, if I can say. We went from you being in the streets, police officer comes up to you, and we jumped all the way to you being in the station. How does that make sense? Well, there are different ways to answer this. The first way to answer this is that in regards to the criminal justice system, the moment that you are detained doesn't matter. It doesn't matter where you are once it's established that you are being detained by the police. So it doesn't matter if you're being detained at the station. It doesn't matter if you're being detained at the back of the car. It doesn't matter if you're being detained outside in the streets while waiting for someone else. It doesn't matter if you're being detained in a city bus. The location of your detention doesn't dilute in any way your constitutional rights or your obligations. I find that for some explanations, it's easier to refer to the station, because then people picture themselves in this closed, dark, damp room by themselves and a clock and perhaps a pen with a set of police officers playing good cop, bad cop with you. That's generally the image that people entertain. But all of this can happen in the streets, next to the police car, or in the back seat of the police car. You can still invoke your right to speak to a lawyer at that moment. You have to still assert your right to remain silent after you have identified yourself at that moment. So bottom line, what I want to communicate is, doesn't matter where you are being detained, it's the same constitutional rights and it's the same obligations. It's possible that the police officer tell you, you're going to be released within 5 minutes. You don't need to speak to a lawyer. What do I think about that? I think it's better for you to be released than anything else. Excuse me. So if they tell you, well, we can't let you speak to a lawyer right now, we don't have a phone, but you should be freed within the next hour or so, then my recommendation is to kind of go with the flow, wait for your release if it actually materializes within the hour, and then call the office and then call a lawyer. Now, definitely, if you're being detained for a longer time and you're still not being able to speak to a lawyer, do repeat again your request and see what happens. This sounds a little weird, but definitely you do have to repeat your request and see what happens. The moment that you're being detained, or you got the handcuffs on and you are the back seat of a car and the cops are talking to each other trying to figure out what to do with you, is not a moment where you are in control of your situation. It's generally the moment where the best thing you can do is keep quiet. Again, you are the own judge of the level of consent, and you are responsible for your own actions. I just want to remind everybody that you're facing police officers, you're facing agents of the state. The power relationships between you and the agents of the state is not necessarily in your favor. And at that moment, your physical integrity, your liberty, your release is the most important thing. Some people pass up on the chance to speak to a lawyer, and it makes sense in some instances. Perhaps I can spend a few minutes explaining to you what is my job once you call me. Once it is established that you are detained or arrested, you are at the station or you are outside, regardless, once you are given the opportunity to speak to a lawyer, why is it that you should speak to a lawyer at that moment? Generally speaking, I do not have a lot of legal advice to give you at that moment. It is not the moment to talk about future strategy for trial. It is not the moment to have a very detailed portrait of what actually happened to you. That moment, that phone call, see it as your bridge to the outside world. It is the moment where you tell someone from the outside to call your loved ones. So when I pick up the phone, I'll ask you, what's your name? What happened briefly? Are you okay? Are you injured? And then, who do you want me to call? Who is waiting for you tonight at home? Who needs to be told if you are going to be detained for the whole night and you're not going to show up anywhere tomorrow morning? Who needs to know? Who do I have to call? In situations where your detention continues through time and you end up in front of a judge detained for your first appearance, the first time you go to court, maybe someone has to show up for bail. Maybe someone has to show up to work out conditions for your release. Who is it that I have to call in order to secure either your release or your transition from the police station to a prison or a federal penitentiary? It's usually a local prison. So that's how I would like people to view the phone call to a lawyer. Some people might think, well, I don't really need legal advice. I don't really need any lawyer to work with me. That's fine. At the office, we help people that want to self-represent for political reasons. That makes full sense. What I want to communicate is that when you are stationed, the only person you can call is a lawyer, and that lawyer will be your bridge between you and your loved ones outside. So that's why, if anything, that's why that phone call is important. 1h37, ça va vite. I think there's some questions.
Yeah, we have some more audience questions if you'd like to answer
Definitely,
them.
I'm ready.
Perfect. So our first one is from Nathalie. Does the police officer have to tell you the reason why you're being detained, or is just being at a protest sufficient reason for them?
They do have to tell you. They do have to tell you why you're being detained. That's a yes, period. Now, they are also allowed to tell you that you're being detained pending investigation. The first few answers that you get, they might be as minimal as that. It might be that, Nathalie, you're being detained right now. We need to identify you. It's for a pending investigation. We'll come back to you in 15 minutes. We just need to sort a few things out. That is possible, and that's not necessarily grounds for concern to me. Generally, the police will already sort of have an idea in their head of why is it that they are arresting you. And keep in mind also that obstruction, well, we'll talk about the different crimes later, and we spoke about one way to do obstruction, but bottom line, obstruction is whenever you pissed a police officer or whenever you didn't obey an order. So if they have either been following you visually during the demo and they saw you tagging this or that, or they asked you to move on the sidewalk and you didn't like it, chances are they already have something in mind. Most of the times, they will answer you in, in half-hearted truth. So they will answer you to make sure that they respect their duty to inform you, but not give you the full information until this case is actually closed for them, until they are rubber stamping charges or you are talking to a lawyer or something like that. Does that answer your question, Nathalie?
Nathalie, let us know if that answers your question. We do have another question from Irene. So what is the most private place to contact your lawyer? Would it be at the station? And if so, could we ask specifically to be taken to the station?
I do not recommend to be asked to be taken to the station because it's not fun generally, and there's a procedure for you to enter the station and leave the station. So if they don't intend on bringing you to the station, do not ask to go there. That would be my general guideline. The lawyers are usually skilled professionals, so before I get to talk to you, if Irene, for example, you are calling me, you are outside the police car and you are calling me, at that moment, my question will be about what is your current situation? Do you have handcuffs on? Who is holding the phone? And it might be possible that if the cop is holding the phone, I ask you to tell him to call me. So those are more peculiar situations where we figure out, the lawyer figures out for you if this is a safe place for you to have the conversation or not. Same thing, if you are at the station, I will ask you, are you alone in the room right now? There are safeguards regarding the confidentiality of our exchanges. The cops don't really eavesdrop that much because, remember, it's not the moment where we talk about strategy. It's not the moment where you start sharing with me what are the name of your friends with you. It's the moment where I ask you, are you okay? Who do I have to call for you from the outside? And generally, I find that cops leave you enough room, leave you alone to do this, and come back once you hung up. So, long story short, you don't need to fight for confidentiality because it is generally it's given by the police officers. They will give you some physical space, and I do not recommend asking to go to the station for increased confidentiality.
Perfect. Thank you for that question, Irene. Our next question is from the student Tessa, and it's in two parts. So the first part is being detained the same as being arrested? And the second is, when is the right moment to ask why I am being detained?
All right. The right moment to ask why is anytime. Anytime. Now, does that guarantee you any answers? It's not clear. But definitely you can ask anytime, at any point, why is this going on? In fact, the more my clients consider their arrest or detention to be unjust, the more they will be voicing loudly this question. So I have absolutely no guideline as to when is the best moment for you to ask questions. I think you should ask questions every single step of the way. Is being detained the same thing as being arrested? Sort of, but not really. It's definitely a lawyerly response, but that is the truth. So being detention is confusing. The Supreme Court defines detention as the moment at which a person does not feel like they can leave the police officers and go on with their business. Detention, on a very theoretical definition, according to the Supreme Court, is the moment at which a person feels like they can't leave the premises and go on with their day. They have to stay there. They have to keep engaging with the police officers. That's when detention starts. Now, sometimes the police officers will actually physically detain you, put the handcuffs on, put you in the back seat of the car, or bring you right away to the station before you're being arrested. And those are generally the detention pending investigation that I was talking to you about. It might be detention pending verification on identification as well, but it covers all everything that happens when you can't leave the premises, but you haven't been formally charged. Arrest happens when the police tells you, you are being charged for blah, blah, blah. You are being arrested for blah, blah, blah. Physically, it might look like the same to you. For lawyers, it's two different worlds. Suffice it to say that for your own knowledge, for your own knowledge, know that your constitutional rights and your obligations are the same, whether you're being detained or arrested. And I guess this is, for me, it's the logical consequence of detention and arrest being very loosely, I guess, flirting together in a very gray area, but make it clear that how you have to act, whether you're being detained or arrested, is the same. You still have to identify yourself, whether you're being detained or arrested. You still have to, you still have to identify yourself, but you can still invoke your right to speak to a lawyer of your choosing, whether you're being arrested or detained, and you can still invoke your right to remain silent, whether you're being arrested or detained.
Perfect. Thank you for the question. The next question, I believe the last question right now that we have is from Robert. Considering the matter is federal, does this advice apply in every province and territory?
Yeah. Oh, yeah. Yes, it does. Yes, it does. What can differ from one province to another might be the rules about how a matter is conducted in the court in front of a judge. There might be some different rules, very, very specifically, but if you are entering the realm of criminal charges, it is definitely federal. Theoretically, if you are my client, Robert, and I've represented you in Montreal a few times, and then you decide to move to Alberta, theoretically, you can ask for my services there. And there are different procedures to do it, but yes, you can ask for my services there, and I get permission to go represent you. And in terms of the trial, in terms of what is a crime, how can the state prove a crime, and what are your constitutional rights, that is the same from one end to the other of the country.
Perfect. Thank you so much, Robert, for the question. And there don't seem to be any other questions right now. So if there are none left, we can move on.
Okay, cool. So I'm looking at the time, 1:45. Perhaps now is a good time to tell you about what are the different crimes that people face generally around political activism. And then we'll briefly talk about Cop Watch. And then I guess I'll just open mic. I'll take all the questions you want to bombard me with. Does that make sense?
That sounds great.
Okay, cool. So, different set of charges. It's not that complicated. It's always the same one. So obstruction is definitely the most interesting one. For a lawyer that works around these issues, obstruction for me is very, very interesting because it is, like I said earlier, I consider it to be the Wild West. I am very interested about how the law will define and redefine obstruction for the years to come. I think there would be a definite link between social movement and the modulation of obstruction, but suffice it to say that obstruction is basically when you don't, when you're annoying the police officer. Definitely, if you're not identifying yourself, that's a straight book. It's a textbook. There you go. It's a textbook case of obstruction. But anything else, there will be a debate in front of the courts. I think that easily 75% of my caseload since 2014 has involved obstruction in one way or another. Almost all of racial profiling case involves some sort of obstruction one way or another. And it's a bit easy to imagine. You're minding your own business. All of a sudden, this cop show up and he starts asking you questions. And you try to go on with your day, but you don't want him to bother you too much. Things get heated a bit. You raise your tone. He raises his tone. All of a sudden, we lost control of the situation because emotions are running high. And why are you talking to me, police officer? And all of a sudden, you end up with obstruction. And then we have to fight in court. So there is some creativity around the definition of obstruction. I think that it would be very difficult for me to give you one straightforward answer. Just know that if you don't identify yourself, it can count as obstruction, and sometimes not obeying to a direct order to the police officer can count as an obstruction. Again, general legal information. Know that there's a lot of debate that can happen in court. I'm not telling you that you will be found guilty every time you don't listen to the police officer, but generally you will probably be detained while they figure out if they arrest you or not. So be mindful of obstruction, but don't try to understand it in detail. Lawyers are still trying to figure that one out. The other one is a bit more intuitive, assault. Assault against police officer you see often. One thing that I think is important to remind you is that assault happens as soon as somebody else's body was touched in any way without their consent. If we talk about sexual assault, this definition makes sense to all of us. Beware and be mindful that it's the same definition when the person in front of you is a police officer. So the moment that there's a contact between your body and the body of a police officer, and the police officer did not consent to that contact, then you can face charges of assault. Do be mindful of that. Can you be charged with assault if it wasn't directly your body? Yeah, it can be assault with a weapon. So if you're throwing a pen, that's a weapon. If you're throwing a rock, that's a weapon. Simple assault is only your body. Assault with a weapon is any other object that is not your body. The object does not need to be defined for it to be a weapon. It might be that the police officer received something on the head. He doesn't know what it is, but he definitely got hit. And you are the one who is charged with assault against a police officer with an unknown object. Definitely possible. What I've seen also in my case is you are smoking a cigarette, minding your own business, living this glamorous political life. Police officer comes up to you, he tries to talk to you, you don't want to. You flick your cigarette, it lands on his boot. Ow, 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 it burns, it hurts. Assault. That has happened. That exists. So be mindful and use the same logic that you have already in your head regarding consent in sexual activity. Well, the same thing applies. Assault is the moment that his body was touched without his consent. Mischief is a third set of charges that we see often in anything related to political activity. Now, mischief, it's important that you follow me on this one, and it's important that you ask all the questions that you need to, because it's not that intuitive. Most of us, when we hear the word mischief, we think about a tag, du vandalisme. We think about objects being broken. We think about objects being soiled. We think about objects being colored. That is only one way to commit a mischief. So if you're breaking someone else's property, if you're damaging someone else's property, that is the intuitive definition of mischief that we have in mind. It can be the property of the city, by the way. It's not just because it's in a public zone doesn't mean that it's a free-for-all. It belongs to someone, and that someone is an entity. It can be a company, it can be a city, it can be a government. Suffice it that that thing belongs to someone. So mischief can happen if you are threatening property, threatening an object. The moment where mischief starts to be a little complicated, but it's just a learning curve. Basically, it's not that complicated, is that mischief can occur in a space. So the first part is mischief against an object, property. But space is also a property, right? If you have a landlord, you are using the space and paying rent to let the landlord allow you to stay there, but it's still his property. Say, for example, you are organizing a sit-in inside the office of a political figure. So you gathered all of your friends, you mobilized for the past 4 months, and it's D-Day. You show up, all of us are laying down on the floor with signs showing that it's a sit-in. That action can be a mischief. How can it be a mischief? Well, everybody is lying on the floor in this semi-public space. The political figure, the député, the representative, cannot use that office like they intended to that morning. They have to tell their administrative assistant, well, look, go home. I'll talk to you tomorrow. They have to call the cops and say, there's a bunch of people that lined up my reception. I cannot welcome anyone. I cannot operate this office. You have to kick them out. It's mischief because that action threatened that property. It's mischief because the property, the space, was not used like it was intended to at that moment. This applies for a sit-in. This applies if you barge into, like I said, someone else's office. This applies if you are, for example, in the offices of Immigration Canada, if they have to close up shop and not deliver the services because there's a bunch of activists blocking the door, that is definitely a mischief because it relates to the space. So long story short, if I put all of this together, know that mischief can relate to an object, but also be mindful that property can mean a space too. And you can commit mischief inside a space. Other thing about mischief, there are two different kinds of mischiefs in the criminal code, and it's according to the value of the crime. So there's mischief less than $5,000 and mischief over $5,000. What does it mean? It means that if the police officer wants to charge you with the crime of mischief, they also have to make the decision of what is the value of your crime. Is it a case of mischief less than 5,000 or mischief over 5,000? If I were to tell you that in the code, the crime of theft also follows this logic. There's theft under 5,000 and theft above 5,000. As far as how the courts perceive this, they see this as different degrees of severity. If I'm stealing $100, it does not carry the same weight. I would not get the same punishment as if I steal $10,000 from my employer. It's the same logic for mischief, but here's where it's different. It's not the value of the damage that you did, it's the value of the object. How does that make sense? Well, say for example, you are fighting for climate justice and you participate in an action near the train track and you decide to get one of those spray, how you call that, canne d'aérosol. So I guess spray paint, and you tag a part of the train with climate justice, anti-cap slogans, whatever it is. You just write your name. We don't care what is it that you did. Definitely it's a mischief because you are attacking property. Is mischief over 5,000 or less than 5,000? Well, we have to look at the value of the whole train. And the whole train is more than $5,000. So you will be charged with mischief over $5,000. Another example, your political action, in the course of your political action, you decide to break a camera. Well, definitely that's property, so mischief, but what's the value of that camera? It's not only that lens, it's the value of the whole network that was, attacked, if I can use the word. So that's definitely a mischief over $5,000. So let's recap on mischief. It's a crime against property. Property can be an object, but property can be space too. Be mindful of that. There are two different crimes of mischief in the criminal code. Less than 5K, over 5K. How is that established? Well, it's the value of the object, of the property entirely, be it an object or a space. Okay, so we covered obstruction, we covered assault, we covered mischief. Breach of condition is really fun for everybody except the lawyers. Breach of condition is something that is problematic in terms of the revolving doors of the criminal justice system. How do you get a breach of condition? Well, to get a breach of condition, you need to have a prior case. It needs to be that you already had a criminal case that you worked through with your lawyer, and that criminal case ended with a bunch of conditions for you, namely, keep the peace, be a good behavior. If you change your address, report it to the court, and so on and so forth. There are a lot of different conditions that can be imposed, but the main one is keep the peace. The first one is keep the peace and be a good behavior. The moment that you are arrested, you are in breach of that condition. The moment that you are arrested, you are in breach of the condition of keep the peace and be of good behavior. One other breach of condition that can happen is if the previous crime was happened in a situation where you were intoxicated, so either you were high or you were drunk, and the court saw it fit to give you the condition of not drinking and not doing drugs unless it's unless it's required by your health status. So if you were found in a demo and you're drinking your beer, it will be a breach of that condition. So people that already went through the system are usually mindful of this. Where there is a learning curve is in the context of you being detained and appearing detained in front of a judge. The judge at that moment, if he decides to release you, he will release you with a set of conditions. Those conditions, see it as a transaction. You exchange conditions for your liberty. So the judge tells you, well, you appear detained in front of me today, but I will not keep you detained until your trial. I will free you, but I need you to respect these conditions. Keep the peace, be a good behavior, tell the court if you change your address, be present every day, every time that your case comes up in court. Those are conditions for your release. And those are extremely, extremely, extremely serious. If you have appeared detained and you have accepted conditions for your release, you must respect them. If you do not respect them, then you have an extra charge of breach of condition. Each breach is a new file. It doesn't go in the same file and darkens things a bit. That's not how it works. It's an added file. And the more you're adding the file, the more the courts have to increase the severity of the punishment that they will impose on you. So do be very careful with conditions. If you have conditions, you should definitely speak to a lawyer before you go to a demo or you engage in political action, especially if it's direct action. And if you have loved ones that have conditions from the court, do be caring about that and do take them seriously and encourage them to take them seriously. Conditions can be changed. Your defense lawyer can work to change some conditions, but it's hard. It can be very hard. These are, you did a transaction. You exchange some conditions for your release. So the conversation will be hard because the Crown prosecutors see it as a favor that they gave to you. They let you out in civil society, and they are just asking you to respect these 5 things. That's a little bit of the mindset you would be walking into. Any questions about that part before we move on to Cop Watch?
I don't see any questions from the audience right now, but maybe this is a good opportunity if you all have any questions about this segment that was just covered. So different types of charges, anything related to that before we move on. We'll give people a few moments. You can always ask questions at the end as well if you can't think of anything right now. We're going to have a little question period at the end. All right, I'm not seeing anything from the audience for the moment, so we can continue and then we'll ask again at the end if anyone has any questions.
And don't be intimidated by anything. If something is not clear, that's because I did not explain it well. So it's okay if your question is just, I didn't get that part at all. Let's move on to Cop Watch. This section of the workshop is rather short, but it's, I guess, the beginning of a conversation that we can have about the criminal justice system. I often get the question of, can I film the cops? Can the cops film me? What's going on with my cell phone if there are police officers involved? Well, nothing in the criminal code, nothing prevents you from filming a police officer, but nothing protects your right to do it directly. That's the first thing. The second thing is that cop watch is a fine line. There's a fine line between cop watch and obstruction. If you remember that obstruction is the moment that you pissed off a police officer, you can be arrested for obstruction, then you have to be very mindful of how you do the cop watch. So my recommendation generally is to reposition yourself in your situation and understand why you're doing cop watch. Are you doing cop watch at that? Perhaps I should explain cop watch. Cop watching is when you see police officers doing something and you find it a bit weird or exaggerated, and you keep a close eye just to make sure that everything is fine, and perhaps you are already thinking about being a witness for that person or something like that. So given that definition, for me, cop watch comes from a place of care. And you always have to be mindful of who are you taking care of. Are you doing cop watch just to have some riot porn on your phone? Or are you doing cop watch because that is really fucked up? Yeah, it is a fucked up situation and you want to film it and perhaps act as a witness for that person. So if you pull out your phone and you start filming them, the first thing you will hear from the police officer is move back, recule, reculer. Please obey. Please move back. You don't need to stop filming. You got two hands and different limbs, right? You can keep filming, but if they ask you to move back, do move back. If you move back from 1-2 steps, that's fine, but you obeyed that order and you're still filming. It serves nobody if you enter inside, if you mingle with the police intervention, because most of the time you're not helping the person who's being arrested and you are attracting attention on you. The cops can just change their mind and go arrest you for obstruction and not obeying the orders, and you don't have all the information that's in front of you. You don't know everything that's going on in the situation. The best way that I can illustrate this is one case that I got from the office. This young man comes up to the office with one charge, simply obstruction. He was outside downtown the night of his birthday. He had fun. People left karaoke. They were moving on to the next venue. While they're walking outside, my client sees a police officer that is slamming someone down on the ground. He perceives that as something very, very violent, and he approaches the scene with his cell phone. So far, so good. However, the police officer told him once to step back, and he did it. He stayed where he was, sometimes even approaching a little more, or at least signaling to the cops that he was definitely not going to obey the order of stepping back. Well, it was very hard to come up with a defense because once we received the evidence, a piece of information that was missing at the moment of the birthday walk was imposed to us, and that information was that the police officer had just arrested someone who had threatened them at gunpoint. So what do? Obviously, my client felt bad because that was not what he had envisioned as his work, as his cop watch, as his behavior at that moment. The police officer don't have time to explain to you why that intervention is right and justified. So what you can see how it's a delicate game. You are allowed to do cop watch. Nothing protects your right to do cop watch and film the police directly. Nothing protects your right, the possibility of you to do that directly. And if you don't, if you're not mindful of what they tell you, you can be facing obstruction charges. So walk that line, use your judgment, be mindful of why you're doing that cop watch and who are you trying to help, who are you trying to serve. And yeah, I think I'm done talking. I'm ready for questions about any topic.
All right. Thank you so much, Arish. That was a very informative presentation, and I hope it's going to be really useful for like a lot of folks are trying to get involved right now with different movements. So hopefully it's going to be very helpful for everyone who tuned in. We do have another question from La Studentessa. Is it helpful to know the police officer's name and ID number? So I'm assuming badge number.
Yeah, thank you. Very relevant question. I am a firm believer that knowledge is power. So if you have that knowledge, definitely, it can always be relevant. It can always be helpful. If you're thinking about actually suing the city and its cops, that is definitely something that we need to have. I need people to be a little bit cautious about ID of the police officers and their badge number. Sometimes during demos, people would sort of impose themselves to the police officer and follow them around until they identify themselves. Again, like Cop Watch, you're walking a fine line. Make sure that you understand why is it that it's important for you at that specific moment to get that information. Knowing that in the case of criminal charge, the police have to identify themselves in the paperwork that I get at the office. If we go to trial together, if you're arrested for obstruction or assault or a breach or whatever, and we receive your evidence, I will have their badge number, I will have their full name, and I will do the research to see if there was ever any ethical concern about them. That is only if you are actually facing criminal charges. The moment where it might be important for you to get that information right away is if you are not charged, but you definitely want to file a complaint with déontologie. We call it commissaire à la déontologie. It's basically the ethics board. It's an ethics complaint that you file against the cop. It is reviewed by cops, and lawyers, defense lawyers generally don't put a lot of hope in the system because it's asking a more experienced police officer to judge the problematic action of a current police officer. So I think it's a bit weird of a system. So if you're not charged at all and you want some sort of accountability, definitely do get the badge and the name. If you don't have it at that moment, don't jeopardize yourself. Don't put yourself in a dangerous or problematic situation just to get it, knowing that the ethical complaint process is not that fruitless at the end. It's not that useful for people at the end. I haven't had a lot of clients who walked out of the process saying, oh, justice was done. I am so happy I did this process. So be skeptical. Be mindful, walk a fine line, use your judgment. Yes, it's important. If you are in deep trouble, I will get that information anyway. If you are just on the surface, if you are in trouble, but only on the surface, do reevaluate how much you are attached to the ethical complaint process. And it would serve you well if you do some research about that before your political action, and it serves you well if you follow some workshops about it. I know le collectif contre la brutalité policière, COBP, I know they've done workshops on that on the past. There's a lot of people in the community that are in the general progressive community that are not lawyers that have experience filing those complaints. So do your homework before, make up your mind about how much you're attracted to the ethical process, and see if it's worth it, if it's worth for you really asserting your right to request the officer's name and badge number.
Great. So there is a follow-up to that question.
Thank you.
If I ask and they refuse, what can I do?
Yeah, it's I think you will start to see a little bit of editorial on my end on this. What can you do? What do you want to do? If you're not being charged, what do you want to do if they don't answer? Perhaps you can see on their uniform, perhaps you can see it, but what is it that you can do? There's not much you can do. I don't see any other way for you to forcibly get that information without putting yourself in more trouble. Perhaps that's a political orientation. You'll be the judge of that. But at the moment that you have a police officer in front of you, if they're not respecting their ethical obligation to identify themselves, you stop there. So this is not a useful answer, but it's definitely a truthful answer.
All right, thank you so much for the question, and thank you so much for the answer. So we have another question from Chloe. Can an officer search your bag, car, etc. if you're being detained?
Thank you, Chloe. Yeah, if you're being detained or arrested, the police officers have a right to summarily search you and your belongings. What does that mean? They can pat you down like this, so on your body, to make sure that you're not hiding any weapons that can be dangerous, and they can go through your things very quickly just to make sure that you don't have anything dangerous on you. That we call an accessory search, and the purpose of that is strictly safety, so that the cops can make sure that this is a safe situation to continue. Anything more invasive than that? Question marks. Anything more invasive than that, we generally, defense lawyers will recommend voicing that you don't agree, but also be aware that there's not much that you can change at that moment. So if the police officer is going through multiple bags and pulling everything on the floor, yes, you can say, sir, I don't agree with this search, and I'm going to speak to my lawyer about it. You can definitely say that. What is it? How is it that you can react beyond that? There's nothing more to do. You cannot just jump on the bag and push them away. You cannot forcibly force them. You cannot force them at that moment to stop seizing and searching through your things. So you can definitely voice the fact that you disagree, but that should be the extent of what you say. Now, that's it for your question, Chloe. But your question also allows me to open, and I guess, another editorial. It might be very frustrating to hear me say, "You just gotta comply," but also keep in mind that this is a very short moment in time where I'm asking you to comply. Down the line, all of that will be very relevant at trial. All of that will be very relevant in your testimony in front of a judge. If you are my client and we're filing for a violation of your constitutional right, and you enter the box of the witness and you testify in front of a judge that you repeated over 5 or 6 times to the police officers that you wanted to speak to a lawyer, what your lawyer's name was, you told them that you disagree with this, you told them that you don't even know why you're being arrested, and this went on for a few minutes, well, all of that is evidence. And all of that is evidence that is crucial, that is super important to your trial in criminal matters. So yes, I am telling you to comply, or at least I'm telling you that it makes my job easier if you comply at that moment. But also keep in mind that that's not the end of it. We might pick up this conversation later on in court.
Perfect. Thank you for the question, Chloe. We have a last question, unless there are other burning questions that come up. But for now, we have one last question from Robert. Can you discuss rights and obligations when the police announce an order to disperse?
Yeah, that's interesting. I have no idea. I really have no idea. This order to disperse has been modulated a lot since 2012. Le Printemps Érable, the student strike. So things have changed a lot. Recently, the Court of Appeal has upheld our right to go to a demo and organize a spontaneous demo. But the work is still ongoing. The jurisprudence, which is I guess, the general body of all the decisions, all the court cases and the written decisions, I don't think that they have directly spoken about dispersion and the order to disperse. There's also been a lot of conversations about how is that order carried out. Does it have to come with a consequence? Is it valid if the cops say just get out, or they have to say you need to get out, otherwise we are pulling heavy artillery, or you have to get out, otherwise you will be intimidated by smoke? That is an ongoing conversation in front of the courts, and it goes beyond really Montreal and Quebec. I've seen a lot of cases, a lot of this conversation coming up in cases around G20 in Toronto a few years ago. This question also came up in Le G7 in June, I think, a couple years ago in Quebec City when they had that meeting. So that's an ongoing conversation, and that's the extent of my answer.
Perfect. So we do have a follow-up question from Robert with regard to police officers being the summary searches that we were just talking about. Robert is asking, how about phones? So are the police officers allowed to search your phone?
They can definitely take your phone. If your phone has a passcode, they cannot force you to open that phone right away without a warrant. Now, they can still take that phone. They can still seize that phone while you're being detained. Can they force you to open it? No. What are the tools that they have to get the information inside a phone without your consent? Then it usually goes through a warrant.
Perfect.
So it is definitely best practice to have a code on your cell phone, and it would not be an obstruction if you refuse. Let me rephrase this one. I do not think that it constitutes a criminal obstruction if you don't give the police officer your passcode to your cell phone in the absence of a warrant.
Perfect. Thank you so much. Thank you to I don't see any more questions. So unless there are burning questions, now's the time. But otherwise, we will once again thank you, Arij, for this wonderful workshop. Super informative. And thank you so much to all of the students who participated and who asked questions. So if there are no other questions, and I don't see any, we will move on to the next segment of the workshop, which is which will be a segment from our Legal Information Clinic. So thank you so much again.
It's a pleasure. Stay safe to stay dangerous, everybody. Take care.
Thanks, you too.
Arij,
yes.
Part of what I'm going to be touching upon is what we call statutory infractions, right? And so, as you know, one of the big problems is oftentimes the cops have full discretion as they want whether or not they want to keep it a statutory infraction, or oops, it becomes obstruction. So would it be possible for you to stay on just a little while longer?
To talk about that?
If there's questions about that, yeah.
Oh yeah, definitely. Yeah, I can. Yeah, for sure.
Or if you want, or even if you want to talk about it now,
I can answer very quickly. And I guess I'll reformulate it using my own words. If I understand the question directly, it would be to basically start with the difference between, for example, obstruction. Obstruction can be a criminal charge, but can also be a ticket. In the city of Montreal, you can receive a ticket, and that's the statutory offense that Walter is talking about. If you are receiving a ticket, then the worst thing that can happen to you is pay money. If you are facing criminal charges, the worst thing that can happen to you range from a criminal record to jail time. So it's a different level of seriousness, and there's like interference.
Well, what I can do, Arij, is I'm going to go quickly through the presentation, right?
But if I can just finish up quickly the answer. So there's a difference between the two in terms of severity, but that is not within your control. It's entirely the police officer who will decide if he wants a ticket or criminal charges. The more political your activity is, the more they will lean towards criminal charge. But do know that it is one tool accessible to lawyers to negotiate that we turn it into a ticket or something like that. Definitely not something that applies automatically, but that's the difference between the two, and it's a tool to the lawyers.
Yeah, and the other question I just wanted to ask right away, because while you're still here, right, is we've heard that over the summer they changed the law so that the police have up to 1 year now in order to add additional charges if they want to change, let's say if a person, unfortunately, a lot of files that we deal with are racial profiling, right? But let's say it was maybe initially a ticket, and then the person said, well, this is obviously racial profiling, and I'm going to make a complaint against this police. The person makes a complaint against the police. Let's say a few months later, then whoops, oh, there's an additional charge that comes now. Obstruction of justice. So it's no longer just a ticket. Now the person's charged with a criminal charge. So, and as I said, previously, and we'll talk about a little bit later on, right? The person had, we would tell the person, wait 6 months, okay? And if there's no additional charges, then we can make the complaint, right? Now it's a year, okay? So I just wanted to have your feedback on that.
Yeah, generally I understand the implications. Generally my perspective is that if the system wants to add charges and they have evidence, then the system has all the tools accessible to them to do it. In terms of strategy, especially for racial profiling cases, between a civil lawsuit, the criminal case, the ethics complaints, and the ticket, generally, the more unjust the situation is, the more we use all these tools available to us. So I am not that worried between the 6 months to a year, because I work from the premise that the state has all the necessary tools to move forward and add charges at any point if they want to do so and if they have the evidence.
Yeah. Okay. In any case, we're gonna be fit. I'm gonna go through this quickly, and if you have any things that you want to add to it, right? There's no problem. Melvin, I just sent you a copy of our police declaration card. Can you just flash that up on the website, or yeah?
Yeah, I was actually going to have that posted afterwards as well.
Okay, well,
in the Facebook event.
Yeah. Okay. In any case, it's the same card that we had 2 years ago, right? Hasn't changed. It's basically exactly what you said. As you said, right? Number one, okay, if they stop you, you ask them, am I being detained? If I'm not, okay, well, then I'm gonna go now. And if I am being detained, then basically the right to silence, right, and the right to a lawyer. No, it's the card. It's the card. I sent you another email, Melvin. It's all right. You know what? We'll just go.
We'll just post it afterward.
Yeah. We'll just go with that. It's all right. It's all right. Okay. But basically, it's a card which we provide to protesters, so that that's the declaration. Yeah. So I don't know. Can you blow that up a bit so people can take a look?
Yeah, we actually have an audience question. This might be a good time to do that. Sure. So Robert is asking, is the 1 year change a reaction to Jordan?
I don't know. I feel like my life right now is a reaction to Jordan. So No, it would be. I don't know. I don't know. I didn't write the law, but perhaps one thing to distinguish is that this is a change that came from the province of Quebec, because it's en matière pénale. This is a change within the power of the Quebec province, and Jordan is relevant in criminal law, so um, throughout Canada. So that's the first distinction that I would talk. But as far as I know, I don't see a direct link. But definitely, Jordan has been a revolution. And for those who need some context, Jordan is the name of a decision from the Supreme Court that basically told all the people working in the criminal justice system to speed up things and stop waiting so long before making decisions.
Yeah.
Because we have a constitutional right to be tried within a reasonable delay.
The unfortunate thing as well that we've been seeing is that Jordan has also started being applied by people that have been accused before the Quebec Human Rights Commission of acts of discrimination. And now their lawyers are saying, hey, Jordan. And I don't think there's been any case law on it yet, but unfortunately it's coming. But that's another issue. So long story short, right, this police card, which we put together with the help of the criminalists, like, for example, Arish and other ones in other parts of Canada. Part of the card you keep, part of the card you give to the police. The card is bilingual. The English part is the part you keep for yourself. The French part is the part that you give to the cops, because the cops usually are French, right? And it's a tearaway card, okay? What they'll usually do is, maybe some of the more conscientious police will actually look at it. And as for the others, most likely they'll just, throw it to the ground. But that being said, as Adish said, you presented them, when you go before, if you need to go before a hearing, you can say, like, I presented this, not only did I ask for my rights, like I gave them a written declaration to my rights, and this is what they did. So, okay. So, I'm not going to go more into that just because we're, all this has been previously covered, and we're going to put the card up on our website as well. Melvin, can you flash to the, the presentation?
Mm-hmm. Yeah, so now, so yes, just to clarify, the card will be placed onto the Facebook event for this event afterwards, so everyone can access it. And then we are now going to move on to, so Walter is from our Legal Information Clinic, and he's going to be talking to us a bit about legal considerations related to immigration or international student status as they relate to activism and social justice work. So Walter, go right ahead.
Yeah, so most of the files that we deal with really, Kark, regarding what we call civil penal infractions, or I guess the more common common term is statutory infractions. Now, statutory infractions, right? These are tickets, as Arish said. These are not criminal offenses. Okay. Next. Okay. So what we'll be covering very quickly, right, are just, just explaining a little bit what the social distancing infraction or ticket is, how to contest, the social distancing fines or any other kind of infractions, right, payments of the fines, immigration considerations, and very quickly, considerations or consequences of, well, we said, because we do a lot with international students, of leaving Canada or just simply, change of address, change of court date, or missing a court date. But all of this is within the context of tickets. It's not criminal law. That's like a whole different thing. And this is something which, you would need to have the access to a lawyer such as Adish. Okay, next. Yeah. So the bottom line is that for social distancing fines, right, because of the their nature, okay, and the nature of COVID-19, you have to constantly take a look at what's happening before you go out to a demonstration. And the reason why we say that is that you know, when you go to a demonstration, the police have like a whole bunch of tools before them in order to control that demonstration. You know, previously they used to give tickets based upon the municipal laws, and as well, they also have the you know, discretion to use the code sécurité routière. But a new tool that has come out, which they could use as well, is COVID-19, social distancing. Okay, and this is also why it's so important when, you know, people are planning demos, right? They keep that in mind as well. Okay, keep on going. Next. Yeah. So basically, and we're going to be providing a copy of this, okay, on our on the Facebook of the CSU, right? So don't worry about having to, you know, understand it all. But once again, it's just a question of, you also need to take a look at what are the particular orders of the day, right? Before you start, before you go out and do that whenvif, okay? Because they're constantly changing, right? For the most part, it's 2 meters apart, but you just need to keep that in mind. The fine is fine of between $1,000 to $6,000. So that's something, okay? Right now we've seen more, like, usually they're giving minimal fines, right? Not maximals, but you never know, okay? And next. So guilty or not guilty plea, okay? So this applies not just to social distancing, but all kinds of tickets that you get. So usually, you know, if a person makes a guilty plea, right away on the statement of infraction, it's very difficult to change that, okay? Because you're giving your guilty plea, and, you know, it's in the process. What we usually, you know, suggest is that if the person has received a ticket, okay, what they can do is they can always plead not guilty to begin with and ask for what we call disclosure of evidence, to see, you know, what is the evidence that the state has against them. And following that, right, if they feel that, you know, okay, yeah, you know, the evidence is quite strong, I don't feel like, you know, going through with this, then they can always change their mind and you know, pay the fine and plead guilty. Next. Okay, so yeah, so basically we're just talking about how it's the prosecution has the burden to prove the guilt of the defendant, you know, making a not guilty plea and requesting evidence, provides time and opportunity to determine the strength of the evidence held by the prosecution, to make a better informed decision on whether or not to pay the fine. And obviously, when a person pleads not guilty initially, right, it's the same principle as in criminal law, silence. In other words, all the person needs to say is not guilty, that they're asking for disclosure of evidence, and that they'll provide details of their defense later once they have disclosure of evidence. Next. Next. Payment of the fine. Next. So here it's a question of, you know, negotiating the fine. Adish touched upon it slightly, you know, partly, right? Depending upon the evidence that you get, right? You know, maybe the evidence is weak, and this is why it's important, you know, always to, if you can, to communicate with the prosecutor before the hearing, because the prosecutor has quite a bit of discretion. I mean, if the case is really weak, or if there's no evidence, right, or just simply, you know, sometimes they've given the ticket to the wrong person, okay, then the prosecutor can obviously decide to withdraw the infraction, or even, you know, to opt for a lesser infraction as well, okay. Yeah. Next. And here we talk about the court fees. Well, the court fees are, determined in accordance with, different laws. One, which is the tariff of court costs and penal matters, and it's always possible as well to ask for. And those, I'm sorry, and those court costs are like $99. Okay, in addition to whatever fine that they're giving to you, if it's contested before the judge. So depending upon the amount that's being ticketed, right? Sometimes and depending upon the evidence, it really isn't that much more if you want to go before a judge. Okay, and it's also possible to ask for postponement, right? Especially what happens sometimes is people come to us at the last minute and say, hey, you know what? I have a hearing tomorrow. So what? Okay. Have you received evidence? No. Okay. Have you asked for it? Yes. Okay. Well, then maybe it'll be possible to ask for postponement of that hearing until you have received the evidence. Okay. Next. And of course, and I'm sure we can talk more about this, right? But as though if there's a person has difficulty, paying fine, right? There are optional or alternative. That's alternatives to the payment of fine. Once again, it always has to be done with the discretion of of the prosecutor. But I'm not going to go into the particulars about it. But we will provide that later on. But there is that possibility. Next. Okay, immigration considerations. Next. So, I mean, basically, when we're talking about immigration considerations, the most important thing is that once again, tickets are not criminal offenses. Okay, if it's a criminal offense, then this is where the danger comes in, and the reason being is that if it's a criminal offense, right, it's not even a question, okay, of whether or not, okay, the sentence that you're given. What the immigration authorities look at is what is the kind of infraction you've been accused of and found guilty of. So, for example, and I don't want to talk too much about this, maybe Anish can talk more about it for criminal, but let's say you have what we call a hybrid offense. In other words, the government can either go for a more serious charge, or which is called a criminal conviction, or it can go for a lesser charge, which is called a summary conviction, right? A criminal conviction can result, in a loss of a person's immigration status. A summary conviction, if it's only summary conviction, right, like shoplifting, okay, for less than a certain amount of money, it will not result in criminal inadmissibility, okay? However, once again, okay, if a person is accused of let's say, a criminal conviction, found guilty, okay, no, I'm sorry, if they're accused of, let's say, a hybrid conviction, right, that gives you, the option of either going criminal or summary, and the judgment is such that the prosecution, okay, has managed to only get a judgment on the summary conviction. Unfortunately, because of the fact that it's a hybrid conviction, right, the person is still inadmissible, even though, instead of being found guilty of the more serious charge, it's a hybrid charge, okay? But for my purposes here, right, which is really that of what we call statutory infractions, they're tickets, they do not render a person inadmissible for immigration reasons. Okay, continue. The only thing, however, that a person needs to be very careful about when they've had a ticket given to them and found guilty of the ticket is what we call misrepresentation. Because for international students, oftentimes they have to, fill out forms, in order to maintain their status or perhaps to get a new status. And oftentimes in these forms, they'll ask, have you ever been accused of any penal or any statutory infractions? Okay. And so, the language is such that have you ever been found guilty, but have you ever been accused, right? And if you say, well, I'm accused, but I wasn't found guilty, and you say, no, because I've never been found guilty of anything. Unfortunately, that's misrepresentation, okay? Because you have to see what the question asks you, right? And if the question asks, a certain specific question on have you ever been accused, right? Then you have to answer it truthfully, because otherwise, if the immigration authorities find out otherwise, right, that you have been accused, then they can hit you with misrepresentation, and you can be banned from Canada for 5 years. And unfortunately, and Adij, you can speak to this, is that the cops in Montreal almost systematically they contact Immigration Canada if they know that the person is a temporary has a temporary immigration status, or worse, that they don't have any immigration status in Canada. Next. Okay, consequences of leaving Canada. Next. Yeah, basically, it's just the common sense, right? If you change address, you have to tell the court, okay, that you change address, and the reason being is that next, if you don't tell them of your change of address, then what can happen is that there can be procedures that are sent to the old address, and obviously, if you're not going to receive these procedures, then there can be a let's see. Yeah. So, there can be a judgment that will proceed in your absence. Okay. So, 6.2 talks about, the obligation to give the address. Let's see, and a postponement as well if you need. Next. Okay, and 6.3 talks about what happens if you miss the date of the hearing. Okay, and it could be for it doesn't have to be just because it was the wrong address and you missed the convocation. But basically, what happens? Okay, if you unfortunately couldn't make it to the date of hearing, well, what can happen is that the judge has a discretion to either adjourn the hearing, and once again, this is always for a civil penal situation or ticket situation, or what they can do is at the request of the prosecutor, they'll say, you know what, we contacted the person, there's no change of address, let's go forward based upon the evidence. Prosecutor feels there's sufficient evidence, judge agrees, and usually it results in a guilty judgment by default. And if the person does have a judgment against them, right, in their absence, then they do have the possibility, once they found out about that judgment, right, of acting within a delay of 15 days in order to file an appeal of the judgment, saying and obviously you have to provide a serious motive as to why they were not able to show up at the hearing and why they only found out about the proceedings later on. Okay, so I think that that ends my part. I know I went over quite quick. If there's any questions, right, you can feel free to ask. As well, we do have the Legal Information Clinic, CSU Legal Information Clinic. You can contact us at any time. We're a free service at the CSU, and all you need to do is just send us an email. And I think you even leave phone messages, but these times it's really sending an email is the best way. And we have law students can help you look at your situation. We can't give legal advice. We can only give legal information. And if your situation is complex enough, right, especially if it involves criminality, then we will refer you to a criminal lawyer who can help with the file. Any questions? Arish, do you have any particular observations?
If there are any additional questions for her, I can absolutely direct those to her. So you can send them to us at campaigns@csu.qc.ca, and those can be directed to her as well. So if there are any questions for Walter, we have about 10 minutes left. So if there are any questions about like immigration status, international student status, and how they affect your rights in terms of protests or in terms of COVID-19 or anything like that, we can take those at this point. So we'll leave a few moments to see if there are any questions.
Maybe you can post back up the police declaration card.
All right, well, I'm not seeing any questions. So this card, the declaration card, will be posted on our Facebook event. So I'm not seeing any questions from the audience. Do you have any last words, Walter, before we close?
Well, we still have like bundles of cards available for people that want to do good demos, right? I've given those cards to our coordinator of external, right? So
Victoria.
Victoria's got like pretty much all her cards. She's got like a couple thousand cards.
Perfect.
So it's just a question of getting in touch with the CSU, and we can provide you with these cards.
Yep, so our contact information will also be posted on the Facebook event. So if ever you're organizing a demo and you want some of these cards, definitely feel free to let us know. We also have like equipment that we can lend out and stuff like that. So we're always interested in supporting community and political initiatives that align with our positions. So if you're doing anything that aligns with what the CSU is working on, we can support your initiative. So with that being said, if there are no questions, thank you so much, Walter, for giving us that little segment. And thank you so much to all the students who participated. This was great. There was a lot of engagement. So we're always happy to see that. And we hope that you learned something new today about legal rights and legal information. So thanks again. And we hope you have a great rest of your day.